Aloha, my name is Julie Mitchell, and I am the Executive Director at ikahi Mediation Center. ikahi is a nonprofit community mediation center serving East Hawaii, and we are one of 5 mediation centers in the state. We were founded in 1983 as a program of the Island of Hawaii YMCA, and in 2006, we became our own independent nonprofit. Our mission is to empower people to come together, to talk and to listen, to explore options and to find their own best solutions. To achieve this mission, we offer mediation, facilitation, and trainings like this one to strengthen the ability of diverse individuals and groups to resolve interpersonal conflicts and community issues. Our Brown Bag Lunch series is held every 3rd Thursday at 12 noon on Zoom, and you do have to register on Eventbrite each time to receive the Zoom link. At the end of this talk, we are going to ask you to fill out a short online survey, which helps with our grant funding for this free series. We will put the survey link in the chat, so please take a moment at the end to give us your thoughts. I will also send out an email later with the slides and the video link for today's talk. And if you're not sure that we have your email, like if you got this Zoom link from a friend, please privately send me your name and email address in the chat box. If you like today's talk, please feel free to register for more in the future. Our next speaker on October 21st, which is Conflict Resolution Day, is Kimberly Dark on the topic, Conflict Does Not Equal Abuse, Taking the Responsibility to Repair. And I will put in the chat the link to that event, as well as the title of it, which to me is very intriguing, and I can't wait to hear about it. So without further ado, I would like to introduce you to our panel of speakers today. We are going to start out with Jeff Gilbreath. He is the Executive Director with Hawaii Community Lending. He will be talking about the emergency rental and utility assistance program that is available in Hawaii County. Then we will have Scott Shishido, who is the managing attorney for the Hilo office of the Legal Aid Society of Hawaii, and he will be talking to us about tenant issues related to the Landlord Tenant Eviction Mediation program. From there, we will move on to David Chee, who is an attorney at law on Oahu and has been helping out with many of these talks around the state, discussing things from the landlord's perspective. And then we will move on to Kate Sims, who is our case manager for landlord tenant issues with West Hawaii Mediation Center. And myself, again, I'm Julie Mitchell, the Executive Director of ikahi Mediation Center, and we'll go into some of the details about the Landlord Tenant Eviction Mediation Program. So without further ado, Jeff, would you mind unmuting yourself and sharing your slides so we can hear what you have to present? Thank you.
Hello, Julie. Yes, absolutely happy to do that. And it's great to see everybody here on this Zoom. I do want to call out just partners in the fight that are part of the Emergency Rental Assistance Program. We have Faith Oshiro here, who's in the trenches processing applications, meeting with families, has been working really hard. One of many the nonprofits we're partner with. And of course, Scott with Legal Aid. Legal Aid has come on as a partner in providing housing stability services, but you'll get more of that in my presentation. So I'll just stop there and get you going. So you folks can see that screen okay? Excellent. So the program that we're talking about today is the Hawaii County Emergency Rental Assistance Program. You should also have and utilities in brackets there, but really what I'm telling you right now is that we have grants for rent, utilities, rental deposits, and even temporary motel and hotel stays for low-income Hawaii Island renters. And if folks go to our website at hawaiicountyerap.org, this will be the landing page that you see. We're providing assistance in more languages than just English. And this is made possible because we have staff at each of the nonprofit partners who can speak in language, engage in language. Okay. The goal of this program is really right now to get $10.4 million out the door to folks who have been directly or indirectly impacted by COVID by September 31. And I want to highlight indirectly, this is a recent change by the federal government that we can fund, yes, folks who've lost employment or work hours due to COVID, but we can also serve those low-income renters on island who are indirectly impacted. Our interpretation of that is that everybody on this Zoom would be considered indirectly impacted by COVID. So essentially, if you're a low-income renter on Hawaii Island, you can benefit from this program. A little overview of the program. We are really proud to be the intermediary and the lead contractor. We do not accept any applications or process those. We are managing all the compliance, financial management, and partnership opportunities. So that's why you see me talking and not nonprofits who are really the ones doing all the hard work. So a shout out to Hope Services, Hawaii County Economic Opportunity Council, Habitat for Humanity, Neighborhood Place of Puna, Hawaii First Federal Credit Union, and the Salvation Army. These are the folks who are processing applications and paying out the funds to the landlords, the utility companies, the property management companies. This means we have not just one back office cutting checks and wiring funds, we have 6. And they're all on island, so you don't have to wait for Honolulu to catch up to get the dollars to the families. We have a maximum assistance amount, both rent and utilities, or utilities rather, not to exceed 15 months. So we can help with 15 months of rent and 15 months of utilities. In the rent can also include rent deposits and that temporary hotel or motel stays. This addition of the hotel and motel stays is critical. We added this because there's just very little affordable housing stock for our low-income families who may be evicted, may not have anywhere to go. And so this is really meant to be temporary in nature, but it is funding that is available. We have been successful at housing families in hotels and motels for 30-day periods. And we have a contingency fund so that if you are a vacation, a rental owner, a hotel, a motel, we can actually provide funds for damage over normal wear and tear. We just added additional services, including legal services like Scott's Shop at Legal Aid under our Housing Stability Services program. I'll talk more about that. And we have just gotten word, you folks should all embrace this. We're not shutting down at the end of December. We're going to go through June 30, 2022. So applications are open, folks should apply, and we are processing payments as we speak. Who can apply? Again, any low-income renter residing on Hawaii Island. That's really who can apply. We're telling folks, don't disapprove yourself. Come in, try and get approved through one of our nonprofit partners, and you never know. Families need to complete just one application with one of our 6 nonprofit partners. If they apply to all 6, you might be thinking, hey, I get a better chance. No, that's not the case. The first application that goes into that nonprofit is the one who will keep it. The other 5 will disapprove the family for duplicate application because we're all sharing a common database. The other thing I would just note is that payments for approved applicants go directly to landlords, property management companies, utility companies, even the hotel stays. Housing stability services are coming soon. So we recently added in not just assistance that we're talking about with you folks here in previous slides, but additional services. So Hope Services and Neighborhood Place of Puna have hired on additional housing navigators. These are folks who can help find rental housing if folks get displaced. Scott and his team at Legal Aid are offering free legal advice and services for rental evictions. It's great to bring them on. And if folks need to set up A household budget, go through a financial action plan. We are proud to announce we're partnering with financial empowerment centers run by Hawaiian Community Assets and Hawaii First Federal Credit Union. These folks can do that financial counseling, but the carrot really is they also have affordable loans that folks may be able to qualify for, including for past due rent. Additional services that I would just note that aren't on here. If you go through the Housing Navigator program, families will have access to additional funding support, including an additional month's deposit for the landlord to keep our local families, our low-income renters, more competitive in the marketplace. Also for application and screening fees, moving fees, damages potentially to the unit. So we have the ability to add those funds onto these stability services. This is the website if you folks want to check it out. It's being updated regularly with information. When you go onto that website, there's really three main options you have. The first is that you'll see a document checklist. And so this is the maximum income threshold based on household, a number of household members who can apply for this program. The rest of those documents under those bolded headlines are the ones that we're going to need, or the nonprofit partners are going to need to process this application. If renters have their 2020 federal tax return, that's all we need in terms of income documentation, and we can get them through to approval. If not, we've got to collect all the rest, and these are from all adult household members. Now, proof of hardship has come up as a concern. With the new changes by the federal government, folks can provide either an unemployment or PUA approval letter, or they can request a written attestation from the nonprofit. So that financial hardship might be something completely different. It may not be related again to unemployment or loss of hours of work. It could be something altogether different, and we have the attestation for that. The applicant just has to request it. These are the 6 nonprofit partners who've been fighting in the trenches, doing all the real hard work as I sit here and talk with folks like you to get the word out. As you go on the website, you click where to apply, these 6 pop up. You can go to their website. You can call them on the phone to complete an application. You can go in person. You can also email if you have any questions or concerns. And so these are our 6 nonprofits. Pick one, apply, and they will process you through. Lastly, what you'll see on the website is our impact. So we have a data dashboard. We have gotten $5 million of the $10.4 million out to 780 households. There are some who have been disapproved, and we're pending primarily documents from others. This gives you a look at why folks are being disapproved. The largest are that folks are either not responding to our nonprofit partners for follow-up, or they're missing certain documentation. And so we always tell folks, please pick up the phone. If our team is calling or answer that email, that'll go a long way. Second is duplicate application. These are the 157 folks who maybe applied at 2 or 3 nonprofits, and we just got one. Approved applications, this just gives you some breakdown of the data. I want to note the employment status really tells us where our economy's at. Over 1 in 2 folks stepping through the doors are currently unemployed. That means quite a bit considering the federal government has stopped its additional assistance for unemployment and PUA. And then of course, we're seeing needs amongst Native Hawaiian, Pacific Islander communities in particular, as well as female head of households, quite a bit higher than male head of households. And here's our approvals. And I would just note that Faith and team members like Faith under this program have helped over 2,300 children and adults stay housed on Hawaii Island. That's powerful, but it's not enough, team. So if you're on this call, you're wondering how you can help, tell your friends, your family, your employees, your coworkers, your employer, please help us get the word out, because this is so critical, not only to help make landlords and property managers whole and utility companies, but to make sure the families have a place to stay. And we anchor the underpinning of our local economy, which is housing. Here's my contact information. I'll come talk at any presentation, any meeting. I'll sit with you one-on-one, whatever you need from me. Hit me up. I'm always here to help and to serve. And with that, I just want to mahalo our partners, and Julie, mahalo for having us. This is excellent. This is an excellent resource you've put together. So mahalo.
Thanks so much to Jeff. He's going to have to take off to be with another meeting. I really appreciate you sharing about the rental and utility assistance as we are talking about the landlord tenant eviction mediation program. It is part of what we talk about in mediation, encouraging tenants and landlords to work together to apply for rental assistance. And we are telling people, you know, don't be shy, don't self-select out. Just try. If you fall below that income category, please do not feel shy about applying. Like, someone else can use it more. We've got the money. The county does not want to give it back to the state, and the state doesn't want to give it back to the feds. We want to give it to our Hawaii County community members who can use it the most. It's going to help both landlords and tenants. So thanks so much, Jeff. Next, we're going to have Scott Shishido from Legal Aid. Again, he is our managing attorney of the Hilo office of Legal Aid Society of Hawaii, which is a nonprofit legal service provider. They specialize in helping community members, especially low-income community members, seniors, and others access legal services. They're part of our Access to Justice coalition here in the state of Hawaii. And Scott, can you please share from the tenant's perspective what we need to know right now, given the new law, Act 57, and what the tenants' rights and responsibilities might be?
Sure, thanks, Julie. Just give me 1 second. I'm gonna share some slides that I prepared. Okay. So one of the first things that we tell folks is that you know, unless your landlord has a court order, they can't really force you out of your residence. So this court order is known as a writ of possession. It has to be issued by the district court. So basically what this means is that without a court order, landlord cannot you know, turn off electricity, water, other utilities, unless the tenant has abandoned or surrendered the premises. And it also means that without a court order and in the absence of any kind of good cause, landlord can't change the locks, otherwise make the property inaccessible to the tenant. Some of the consequences of eviction, you know, public record of an eviction, and this could be used against the tenant when they're applying for their next prospective residence. If it comes to a lawsuit and if the landlord prevails, the tenant could be liable for attorney's fees and costs. There usually will be an adverse impact on their credit score. And one thing that we're really concerned about is if they do have a Section 8 voucher and they do get an eviction, they're looking at a potential loss of that voucher. Not sure how many of you are aware of this, so I just wanted to point it out. The CDC eviction moratorium, it was intended to stop evictions for non-payment of rent. For counties that had a high transmission rate of COVID-19. But this order was recently overturned by the US Supreme Court. And so it very likely doesn't provide any kind of legal protection for a tenant facing an eviction lawsuit. So generally, this is the process that is followed. You know, the court process for an eviction. The first thing is a notice of termination issued by the landlord. The next would be a filing of the case and then serving the tenant with the documents, followed by a return hearing. And this is where the tenant can answer or deny, you know, the complaint or whether they should be evicted. After that initial return hearing, if there is a denial, usually there would be a mediation ordered by the court so the parties could try to work something out. If no agreement could be reached, the parties would come back to court, report that at a hearing, and have it set for a trial. And at the trial, you know, everyone makes their argument about why they should or should not be able to stay. And if the landlord wins, you know, they get that writ of possession that I had mentioned earlier, and the tenant has to move out. And then at some point after all of that, the court would set a subsequent trial on the issue of damages. So this would be where issues of back rent and any damages to the property get decided. So with Act 57 really only affected the first two phases of this eviction process. And one thing to point out is just to keep in mind, this Act 57, it only applies to evictions related to the non-payment of rent. So if it's an eviction for any other reason, then this is not the process that a landlord would have to follow. So the main, I guess, high points of the act are that it affects what must be in the termination notice. It also affects when the complaint and the summons can be filed after the issuing of that termination notice. And it also affects when the lawsuit itself can be filed by the landlord. So this is just a general summary of kind of the major points or the major changes. So one of them is that it built a timeline in for when a landlord could file an eviction based on how many numbers of months the tenant is behind in rent. And once the landlord can initiate the process, the notice of termination requires a lot more than it would normally require prior to the enactment of Act 57. The termination notice has to address 13 specific items. I won't go into all of those now, but it's a lot more than tenant or landlords used to have to include. But even if this notice doesn't include all of the elements that are required, the court can still decide to allow the lawsuit, the landlord to fix any of the deficiencies, and then the lawsuit can still go forward without dismissing it. So the notice of termination, it has to give the tenant 15 days notice, whereas before it was 5 days. And within this first 15-day period, one of the things the notice has to do is advise the tenant of their right to request mediation. So if the tenant requests mediation within that 15-day period, then the landlord has to wait an additional 15 days before they can file the lawsuit. So a total of 30 days from issuing the initial notice. But if the tenant doesn't request any mediation or doesn't otherwise respond to the notice, then the landlord can go ahead and proceed and file that lawsuit 15 days after issuing the notice. And then another thing to keep in mind is that Act 57 is only in effect until August 6, 2022. So after that, then the process will go back to the pre-Act 57 steps. So just a few things that were affected by the governor's state of emergency eviction moratorium. So it affected rent increases were prohibited for that period of time. Holdover rent was also put on hold for that period of time. And if the landlord or if the property had a federally backed loan, there was restrictions on penalties and other charges related to the non-payment of the rent. And then late fees are always, well, at least under the statute of 52121, late fees are always capped at 8% of rent due. And then the attorney's fees that can be awarded have to be limited to 25% of the principal judgment, and they can only be ordered after the case is actually adjudicated by the court. And then these are just some actions that are always prohibited by landlords. So kind of mentioned this with my first slide, is that so for an illegal lockout, unless there's a court order or the landlord has good cause, they can't change the locks, move the door, otherwise make the property inaccessible to the tenant. And for the utility shut off, if the landlord doesn't have a court order, or if the tenant hasn't abandoned or surrendered the premises, then landlord has to leave electricity on, hot water and gas, and any of the other essential services. And the damages that are available if the landlord violates these statutes is, so for an illegal lockout, a tenant can either get 2 months of free rent, or they can get damages equal to the amount of what the 2 months of rent would have been. And for the illegal utility shut off, the damages are 3 times the amount of the rent, or $1,000, whichever is greater of the two. And then finally, this is just like a summary of kind of the steps we advise tenants to take. And even though we say first to respond to the mediation center and then apply for rental assistance, if you've already gotten a notice of termination, one thing we suggested that even before you get a notice of termination, if you're behind on rent and you qualify for the programs that Jeff was just talking about, you should definitely get that application in, because the issue of rent is going to at some point have to be resolved with the landlord. And before folks go to mediation, we highly encourage them to make a budget so that way they can actually agree to something that is feasible for them financially. And then finally, if you need legal assistance, we invite folks to either call us or apply online for our services. And of course, attend the mediation, and most importantly, attend the court hearing if it gets to that, because if a tenant doesn't show up, the court will enter default and very likely issue the writ of possession then and there, and the tenant would have to vacate. So that's all I have, Julie. Sorry if I went a little over my 5 minutes, but
Thank you so much, Scott. I really appreciate your participating. I put the legal aid website in the chat, so if people want to click into that and take a look, please do. And if you have any questions, you can put them in the chat too, and hopefully we can have Scott and David monitor those at some point, and we hope to have time at the end to answer questions. So now we're going to have David Chee. He's an attorney on Oahu who represents landlords, and he's been talking a lot about Act 57 and how mediation can assist both landlords and tenants with the new requirements. So David, take it away.
Okay, thanks. So yeah, I am a attorney that practices in landlord tenant, and mainly what I do is represent landlords. So I participated in the drafting of Act 57, which modified the landlord tenant code to take into account the moratorium that the governor had issued. And so Act 57, the whole purpose of it is to sort of ease the world back into, well, not the world, ease Hawaii back into the more normal situation where if a tenant doesn't pay the rent, then the tenant could be evicted. But I think that the thing that's kind of important, especially in the context of talking about mediation and problem solving, is to kind of understand what it is that landlords, in my experience at least, what landlords really want. And that is that what landlords really want is, they don't, if they come to me and they say that they want somebody evicted, that's like coming to your doctor and saying that you want your leg amputated. You probably don't really want that. What you really want is your leg to work, right? And so what you usually, if somebody comes to me and says, I need my tenant evicted, the next question is why? What's going on? What's the problem? And now, because of the eviction moratorium, what we are seeing is just tons and tons of cases that are coming in where a tenant hasn't paid the rent because the governor said that they didn't have to. And so now that they have to, now it's a problem, and now it's a problem for all of us to solve. It's a problem the problem that the legislature has kind of tried to solve by sending everybody to mediation. So let's talk about it a little bit. The way to solve problems, if you're a landlord, is to take action. If you do nothing, if a landlord does nothing, then nothing's going to happen. If you don't actually require a tenant to pay the rent, then the tenant's not going to pay the rent. Now, that's not always true. But if you're sitting in a situation where a tenant hasn't paid the rent for the last 15 months, then if you don't do something, I don't know that it's likely that that anything's going to change. So the first thing that I think a landlord should do is follow the requirements of Act 57, which is to send out the 15-day letter to the tenants that ask the tenants to pay the rent. That the form of the letter is actually very complex. Previously, the law had this really simple requirement where all you needed to send out was a letter that said, hey, you owe rent. If you don't pay within 5 business days, then I'm going to terminate your tenancy. And then this new law that I helped write, now has a 13-point thing that needs to be included, 13 points that need to be stated in the notice letter. Luckily, there is a version of the letter that was worked on by, a version of the form letter that was worked on by me, Dan O'Meara from Legal Aid, and other people to comply with the law. And you can actually download that form at repnakamura.com. So Rep Nakamura, I believe, is a Kauai representative, and she has hosted on her website the various Act 57 letters. You'd have to look for the version that is specific for your island. So there's a version that is specific for Hawaii Island that you can download and you can use if you're a landlord. And so follow the directions. The directions on how to use the letter are in the letter. So if a landlord wants to start up a process of discussing with their tenant, the easiest thing to do, send the letter. And then once they've sent the letter, they have to give a copy of the letter to the Mediation Center. The Mediation Center then takes over, going and contacting people to arrange for mediation. And it's really, my experience with mediation so far has been that there have been really excellent results from mediation. And I attribute that to a couple of things. One is that if a tenant hasn't paid the rent for like 15 months, then they pretty much know that there's a problem, and they pretty much are now, open to solutions. There's a lot less fighting than I would have expected, at least from tenants, because I think at this point, most tenants kind of recognize, yeah, I owe a lot of money, I owe a lot of rent, is there something that we can do to fix this? So I think tenants are generally pretty open to working something out in mediation. Also, if tenants can work something out in mediation, they can avoid a lawsuit. But the good thing is that landlords can also avoid a lawsuit if they work something out in mediation. Most landlords don't want to engage in a lawsuit with their tenants because it's expensive. It's like how I make my living. So I would think that if I was a landlord, if there was some way to avoid having to actually evict my tenant, I would like to do that. So mediation, in that way, I think works out well for both sides. And as I had indicated, so far it's been, really successful, far more successful than I was expecting, simply because at this point, I think that everybody kind of recognizes that there isn't really too much to fight over. The only thing that's really left to do is figure out what the solution is to the problem. So there's not so much, arguing about whether or not somebody owes money or doesn't owe money. Those arguments are pretty much, they just don't happen anymore because so much money is owed that it's obviously something is owed. Now it's, we have to decide what to do with it. The other thing if you go to mediation and you don't get a good result, you don't get some sort of agreement as to what to do. The other thing I've noted is that when a landlord actually files a lawsuit against a tenant for eviction, then in a high percentage of cases, the tenants simply leave. They don't even stick around to get served with the papers. Oftentimes they just leave. And so if I was a landlord and I wanted to make sure that I got my place back, I would first engage in mediation to try to see if I could come up with an agreement that made sense for both me and for the tenant. And if that couldn't happen, I would file the lawsuit, because then, we can get the matter, we can start up the matter. And if the tenant decides to stay and fight, then good. You can bring it in front of a judge and let a judge decide, because there's very few defenses to a non-payment eviction. So because there are very few defenses, I think bringing it to a judge makes a lot of sense. Let the judge talk to them and let the judge try and talk the tenant, talk some sense into the situation. The last thing I wanted to say is that right now, I've noticed that there's a lot of landlords who are really mad. They've had to make their mortgage payments. They've had to do without income for a long time, and they are just tired of it, and they just want to get rid of their problem. Basically, they want to get rid of their tenants because they view the tenants as embodying their problem. I encourage people to actually look at it as a business problem. If you've got a tenant who can otherwise pay the rent, who had a problem, there are a lot of good business reasons to continue to keep the tenant. Now, of course, if you're already so mad that you just can't see straight, well, then, then business doesn't really matter. But to a large extent, I think, I view the landlord-tenant relationship as a business relationship. And it's one that if you can save the relationship, there's a lot of money to be saved by maintaining that partnership. But, you know, if you can't do it, can't do it. And that's why I have a job. Okay, I'm done. Thanks.
Thanks so much, David. We appreciate you sharing. Someone asked a question. We will be giving a copy of the slides for the whole presentation. So there'll be 3 different sets of slides that we're doing. Kate's going to load the set from the Mediation Center. So Kate Sims, who is the case manager on landlord tenant cases, and I, Julie Mitchell, executive director for Ikahi Mediation Center. We are going to be co-presenting the section about how the mediations go. And then David, can you take a look at the question that's in the chat and handle that while we're doing our presentation? And Kate, you just need to unmute yourself and click on that second button to get the full title in there. Click one more time.
Okay, whoops,
Oh.
I went too far. Whoops.
Okay, let's go back one.
Okay. Easier said than done. Okay, so I am with the West Hawaii Mediation Center. I'm the case manager, and also I'm doing a lot of the mediations for the Landlord Tenant Eviction program. And a lot of this has been explained already, so I won't go into too much depth, but I do want to just say that it has had an enormous effect to insist that mediation take place. By the way, the tenant gets a choice, the landlord does not. So there are tenants who decide they don't want to mediate. Occasionally, I probably talk to one of those a couple times a week where people will just decide not to mediate. They'll just get out of the place or whatever. They know their time is up, they're done. But a lot of times I hear from both landlords or tenants that the notice has been given and they're ready to go. So this new law says that tenants must be offered the opportunity for mediation. They don't have to do it, but they are offered the opportunity. We do it for free. And at this stage, because we've had fewer of them than we expected, we're also, we're following up if there needs to be a second mediation. We've been helping people with that as well. So once the notice is given, landlords must provide that notice to the tenants, and at the same time, they're supposed to give it to the mediation centers. That doesn't always happen exactly like that. Often it's the tenants who will call up because they've received the notification and they're scared. I might just emphasize that usually both sides are scared. This is usually a scary situation when there has been a lack of rent for a long period of time. And so one of the things that I feel like we need to focus on and deal with in a mediation is just the relationship, building the relationship such that they can talk to each other, recognize where the problem areas are and what they need to do as they work together going forward. There are 2 different places, obviously. East Hawaii, they would go to Ikahi, or if it's in West Hawaii, that we're talking about where the rental is, not necessarily where the landlord is. Sometimes the landlord's living on the mainland, or sometimes they're living in the other side of the island, but we're addressing it from the mediation center. Where the rental is where we will take on that case. Okay, I'm not sure. Can everybody see this? Is this visible? Okay. So it's really the most important thing is for the tenant to get a hold of us or the landlord to get a hold of us so that we have this 15-day period during which we need to schedule, right? So it's not a very long time. And especially as some of our calendars get full, it's important to have a quick notification and to move into the mediation scheduling process. We ask some basic information, including, some demographic information that we need for our reporting. They're usually scheduled Monday through Friday, but I've found that a lot of times, if need be, we'll schedule. A lot of people like them late in the day after work, and I've had a few requests for Saturdays as well. So we are making that available as well. And then the case manager will let people know what the date and time will be of the mediation and sends a Zoom link. Right now, most of our mediations are in Zoom. Most people are okay with that. It's safer for them. And if they have the technology, they do that. But we will, if they can't do it by Zoom, we can offer them a face-to-face mediation as well. So yeah, this is just if we don't schedule that mediation, if the mediation isn't scheduled within 15 days, or it hasn't been mediated within 30, the landlord at that stage has the right to move on to file for eviction. So we're in a hurry when we get those notifications. Once the mediation session is scheduled with the tenant and the landlord, we'll be notified and we'll get the Zoom links and get moving on that pretty quickly. Most of mediations in the west side, I don't know what's happening on the east side, Julie, but we're getting most of them. Most of the mediations are done within a week. Okay, this is we're doing it by Zoom. We can do it in the center. If somebody needs to have help with equipment, we can sometimes help with that. If they need to have an interpreter, we can also provide that as well. In preparation for the rental, for the mediation, they should always have applied for rental assistance. That doesn't always happen. I find that a lot of times tenants are very nervous about approaching that process for whatever reason. It often asks, information about their finances, and it makes them uncomfortable or unsure. Often it's not until they get into mediation when we have to kind of get the landlord and tenant working together so that they get those applications done. We also encourage them to talk to an attorney, to talk to legal aid. I know legal aid is like their phone is ringing off the hook because we keep sending them to get some information about what are their rights. Sorry, let me go back. We ask them to think about potential outcomes. What is a reasonable timeline? What do they think they can do? A lot of people, I've had a lot of very young renters, and I've encouraged them to see a financial counselor because they really are over their heads before they know it. Sorry, I keep pressing that before I'm ready. Also, yes, I encourage them to think about what are their alternatives to housing, whether it is to move in with a family member or to find another place, to begin to come into the mediation a little bit more armed with possibilities. Is this my turn still? Am I still on?
I think this is where I was going to be taking over. I can't remember exactly.
Okay.
I'm happy to take it. So what, some people aren't even sure exactly what mediation is. And how does it work? So basically, we try to prepare people ahead of time as much as possible by the case managers talking to the landlords and tenants and letting them know what to expect. So we do mediation as a private and it's an informal process. So we send out to everyone in advance a confidentiality agreement. Everyone signs that in advance of the mediation. Basically, that says that mediation communications are confidential. They can't be used later in a court of law, so that people feel like they can have a frank discussion in mediation. And if it works out, great. If it doesn't work out, they can still go on and take all other options remain available to them. We can have interpreters being available to do intakes over the phone as well as during the mediation. So we don't want to have language be a barrier to service. We're scheduling the mediation centers for an hour and a half, though I know some of them have gone a bit longer than that, and sometimes another session is needed. So we will work with the group who we're mediating with to gear it to that particular instance. And then how the mediation session works is we start out all together. The mediator does an opening about what to expect during the session, what are the ground rules, and then ask each person, the landlord and the tenant, to give a little overview about what the situation is. And then we'll meet privately with the landlord and the tenant, and we'll go back and forth like that a couple times. And then usually we come back at the end and we discuss the options and negotiate and work together to see what the next steps are. In these instances, we've had a high agreement rate, higher than our general program. So we've been working together to type up an agreement with everyone there. If for some reason there's any fear or intimidation or any issues where there's safeties of concern, we can, if upon the request of a party, do the whole mediation separately, where the mediator just goes back and forth between the different parties, but that's a little unusual. Next slide. So the mediators are going to do a lot to try to understand the situation. They're going to really want to listen deeply to the landlord and the tenant about the situation. They're going to ask about rental assistance. They're going to ask what the status of rental assistance is. They're going to find out why they did or didn't apply, and were there any barriers, and is there anything that we can do to help them create a plan for next steps to try to get that process flowing smoothly. We're going to ask people, what's your situation? A lot of people lost jobs and they're getting back gradually, or they had unemployment, but now they don't. So what do they see their cash flow being? What will they be able to afford going forward in terms of rent and back rent? And do they even want to remain in the residence? Sometimes we've had agreements during these where everybody's ready to end the relationship, and they negotiate something like the tenant agrees to leave, the landlord gets the property back, and they keep the security deposit, but some or all of the back rent is waived because they just want to end things without going to court. So lots of creative solutions are possible. Next slide. And the mediator's job is to help facilitate this dialogue, the talking, listening, exploring options, and helping people come up with their own best solutions. So in mediation, the parties themselves decide what's going to happen. That's very different in court. The judge decides. In court, the judge is bound by the rule of law and cannot mandate things like payment plans. The judge can give damages, the judge can give the unit back to the landlord, but the judge cannot negotiate and come up with detailed steps of how all things will be decided. Next slide. So when we talk to the landlord, we want to make sure what is most important to them. David mentioned this. Do they want to get the back rent? I mean, at this point, some people are owed $10,000, $20,000. Or are they really wanting the tenant to move out, in which case they may or may not ever be able to recoup that back rent because they'd have to go to collections or garnishment, and maybe the person doesn't have anything. So applying for that rental assistance can be a win-win for both of them. The landlord gets the money that's owed, the tenant gets to not have that back rent debt be hanging over their shoulders. What is the relationship like before COVID? Was it amenable? Is this a good tenant that you really want to keep in the unit because everything was fine before this? And what are they interested in lease renewal? Are they on a month-to-month? Do they want to continue that? Is rent reduction possible? Would you waive some or part of the rent that's back due if they agree to move out? So we're looking for all the options available. Next slide. And mediation agreements can include many different terms. Each mediation agreement is completely unique from every other one. They do not say the same thing each time. It's based on who's in the room and what it is they want to talk about. So we can write an agreement that they're going to apply for rental assistance together, the timeline for doing that, the communications around doing that. We could write up a payment plan to cover back rent owed. So if rental assistance is received and it covers all the months, then this will happen. If it's applied for and it's not received, then this is going to happen. Or let's agree that we want to part ways and we're going to come up with a date by which that can happen. And we're still going to talk about what's going to happen to the rental, back rent, the security deposit, etc. We want to come up with a plan that everybody can follow. We want our mediation agreements to be a path towards success for the participants. Next slide. We are hoping, the idea behind Act 57 is to divert cases from the court system to mediation. The idea is to prevent evictions and homelessness if at all possible. If that's not possible, these cases will go to the court. The judge at the court hearing may refer them back to mediation. We already mediate landlord tenant cases on a regular basis in district court, and Act 57 allows the judge the discretion to refer to mediation if it's a 15-day notice for non-payment of rent. The judge has the discretion to send to mediation, so you might as well do it first and early before you spend your time, money, and effort to file in court. Next slide. So again, contact us as soon as possible. If you're a landlord, if you're a tenant, please don't wait. Please get us your notice. Please call us, email us so we can help you. We have a lot of resources that are available to people. Legal Aid has 2 wonderful documents called Landlord Rights and Responsibilities and Tenants Rights and Responsibilities, and it talks all about this program and what folks should do. I will include that with the email out to everyone who is here. We want to make sure that both landlords and tenants are doing the work that they need to do to successfully mediate. Next slide. So if you're on here and you're not a landlord and a tenant, you're a good neighbor, you work for an agency, please get the word out. This is a free program. It's being funded through the County of Hawaii, through state funding, through federal funding. There's no cost to participant. If tenants need help with the notice, encouragement to look at it because it's very intimidating, it's long. And also, if they need help with any kind of technical assistance or English is not their first language, you can call on someone's behalf and offer to help them, and we can hook up with them via interpretations, translated documents. We want to move forward as quickly as possible, so we're staying in alignment with the act. However, if it happens to be after the 15 days, if it's the 16th or 17th day, we still want to hear from you. There's still time to get mediation in. Even if a landlord is filing, it takes time to get on the court docket. So there's some leeway there that we can get the mediation in. Next slide. And the paperwork, again, we put the link to Rep. Nakamura's website. Landlords are still not sure, some of them, what to do, what kind of notice to use. We've gotten 5-day notices, which are prohibited right now. We've gotten people not knowing how to file these notices. Again, Legal Aid has a sort of an outline of what needs to be in the notice that we can share with landlords. And we're happy to help with any equipment issues for a landlord or tenant who does not have good connectivity. They don't have a device that they can use, that we will help them with the tech issue so that they can come into our office possibly and mediate, or perhaps they can mediate from another office of a different social service agency or a friend's house, because some people just need a little bit of help with the Zoom technology. Next slide. And then again, gathering those resources to make sure that you come in informed to the mediation is really helpful, that you know what your legal rights are, that you understand what your budget is, that you have a plan if this doesn't work out and you're going to be not in the unit anymore. Be forward thinking about how you want to handle that if you're the tenant. And for the landlord, thinking about, what is most advantageous to me? If the tenant is still in my unit, I can get that back rent from the rental assistance programs. And if I evict them in court, you may never be able to collect those monies. So making those kind of thoughtful what ifs in your mind before and during the mediation can really help you stay flexible and open-minded enough to negotiate while you're mediating. Next slide. And then the benefits of mediation, there's many benefits. I mean, there's a relationship between the landlord and tenant that can be preserved. Mediation is really a safe, private process. The participants are the decision makers. It's informal. It's not intimidating like going to court is. The mediators are impartial. They're there to support the conversation, help people to negotiate. And then again, if you can avoid eviction, why not do that through mediation? Next slide. Oh, this is how to get in touch with us. So we do have special designated phone numbers, emails, and web pages that are related to the free landlord tenant eviction mediation program. And again, the landlords and tenants want to be in contact with the mediation center where their rental unit is located. So where the tenant lives. So the free landlord tenant mediation program is available specifically for Act 57 mediations. And if you, as you're might be gathering, we do offer landlord tenant mediations for all situations. So we're available to help any landlord or tenant with any issue, as long as both parties are willing to mediate with us. So let's see here. We are really out of time almost. So I haven't seen any more questions coming into the chat box. I want to give a few closing remarks so we stay on time. And if we do see any questions come into the chat box, we'll try to answer them in the time we have left. So I really want to thank our presenters today, Jeff from Hawaii Community Assets, Scott from Legal Aid Society of Hawaii, David, attorney at law, Kate from West Hawaii Mediation Center, for joining us here today, and all of you for being with us. I would like to ask you to take a few minutes to fill out our short online survey. I'm putting the link in the chat box now. And this, your feedback really helps us know not only how we did today, but also we have grant funding for this free brown bag lunch series. Do check your emails in the next few days or possibly next week for the slides and the video link. And we really appreciate that you all spent your lunch hour with us, and hope to see you again next month. Before we sign off, are there any questions that anyone would like to ask? Okay, I'm not seeing anything in the chat, or I'm not seeing any raised hands easily. So we will end on time at 1 o'clock here. And thank you so much for spending your time with us. And we hope to see you next month. Again, the speaker on October 21st, which is Conflict Resolution Day. That will be Kimberly Dark on the topic, conflict does not equal abuse. So you can sign up on Eventbrite. And the list of resources, someone's asking if we can get a list of resources. Yes, we will attach many things to the email for everybody who is with us today. So in addition to the slides, we'll give some additional resources for you folks. Thanks so much. Aloha.